All right, in this explainer, we are diving deep into a topic that is the absolute bedrock of the paralegal profession, competence. And listen, this isn't just some abstract idea. It's a core concept that you are definitely going to be tested on. So we're going to break down exactly what you need to know to nail those exam questions.
So here's our game plan. First, we'll start with the big picture, why this all matters so much. Then we'll get super practical and learn how to spot competence issues in those tricky exam scenarios. After that, we'll cover the core rules you just have to memorize, what your options are when you realize you're not competent, and, this is a big one, how to avoid the common traps the exam will set for you. And finally, we'll wrap up by looking at the very real consequences of getting this wrong. Let's jump in.
Okay, first up, the big picture. Why is competence such a massive deal on your licensing exam? Well, it's simple. It is the foundation for everything else you do as a paralegal. I guarantee you, on your exam, you are going to see questions that all boil down to this one fundamental point. Before you even think about signing a retainer, before you even really dig into the client's story, there is one question you absolutely must answer first. Am I competent to handle this? And it's so important to understand this. Competence isn't about being the best or being perfect. It's about meeting a minimum standard. And if you fail to meet that standard, the consequences are huge. You're not just letting your client down, you're discrediting the entire profession and damaging the public's faith in the justice system. The stakes really couldn't be higher. All right, now let's talk about how you can spot these competence issues in the wild, in the multiple choice questions you're going to be facing. The exam will give you these little stories, these fact patterns that have specific triggers baked into them. Your job is to recognize those triggers immediately. So when you're reading a scenario, and it mentions that the law is brand new, or it's a really niche area, that should be a massive red flag. Your brain should immediately go, this is testing the knowledge part of competence. Do I actually know the law and the procedures for this very specific, maybe even complicated area? Okay, here's another super common trigger. If a case requires you to use some piece of technology that you never touched before, like a new e-discovery platform or something, that's a direct test of your technological competence. It's literally your duty to understand not just the benefits, but also the risks of any tech you use. And finally, you gotta watch out for scenarios where your general experience just doesn't quite match what the client needs. Maybe you've done a ton of standard landlord-tenant cases, but this new client has a really complex commercial lease dispute. That gap between your general know-how and the specific skills needed for this file, that's a huge competency issue. Okay, now for the stuff you absolutely have to know cold. These are the core rules. You need to have these memorized inside and out for your exam. The official definition from Rule 3.0 is everything. Notice it's not just about what you know. It's about having and, this is the key word, applying the right knowledge, skills, and attributes. You can have all the knowledge in the world, but if you can't apply it, you're not competent. And that definition gets broken down into these 6 distinct pieces. Think of these as the 6 areas the exam can test you on. You really need to know what each one means, from your legal research skills and judgment, all the way to how you manage client expectations, and, of course, your own ongoing professional development. And speaking of professional development, let's talk about CPD, or continuing professional development. You know how exams just love asking about specific numbers, right? Well, this is a goldmine for them, so you need to know these numbers perfectly. First, the big number, 12. For a full calendar year of providing legal services, you have to complete a minimum of 12 hours of eligible CPD activities. Easy enough to remember, right? 1 hour for each month you're practicing. Now, out of those 12 hours, at least 3 of them have to be on professionalism topics. We're talking ethics, practice management, that kind of thing. And here's the crucial detail. Unlike your other hours, these professionalism hours must be accredited by the Law Society. And to get even more granular, within those 3 professionalism hours, at least 1 hour has to be specifically on equality, diversity, and inclusion, or EDI. Now remember, this EDI hour isn't an extra hour. It's part of your 3 professionalism hours. Okay, so what happens when you have that moment of realization? Wow, I am not competent to handle this file. What do you actually do? Well, the rules give you a very clear 3-step roadmap. And this is a classic application-style question on the exam. You have exactly 3 options, and only 3. First, you can just decline the case. Simple. Second, you can go to the client and get their permission to bring in another licensee who is competent to help. Or third, You can get the client's consent to get yourself up to speed. But, and this is a big but, only if you can do it without causing them any undue delay, risk, or extra cost. All right, you'll want to pay close attention here. This next section is absolutely critical. The exam loves, and I mean loves, to test your ability to tell the difference between two very similar concepts. This is where so many people lose easy marks if they're not careful. The absolute classic trap is confusing competence with quality of service. Think of it like this. Competence is a part of providing good service, but it's not the whole package. You could be a legal genius, totally competent, but if you're constantly missing deadlines or never returning your clients' calls, you are failing to provide quality service. And the rules are not messing around here. They make it crystal clear. A failure to meet that minimum standard of competence can get you into some serious hot water. This isn't just about providing bad service, it's a breach of a core professional duty that can lead to actual discipline. Finally, let's talk about the bottom line. What's the real fallout when a paralegal is incompetent? The consequences are like a ripple in a pond. They spread out and affect absolutely everyone involved. I mean, just look at how devastating the impact of incompetence is. Obviously, the client suffers because their interests aren't served, but it doesn't stop there. The reputation of the entire profession takes a hit, public trust in the justice system gets eroded, and of course, the paralegal themselves faces disciplinary action. So yeah, this is not a minor slip-up. It is a fundamental failure that can end a career and cause very real harm to people. And that is exactly why the Law Society takes it so seriously and why it's a guaranteed topic on your licensing exam. And that brings us to the end. As you're studying for your exam, I want you to keep this final question in mind. Because really, confirming your own competence isn't just about passing a test. It's a professional obligation you are going to carry with you every single day for the rest of your career. Good luck with your studies.